Good morning and welcome. We're so glad you're able to join us for today's employment law update, Staying Compliant in 2025. I'd like to begin by introducing today's presenters. My name is Allison Callahan. I'm a partner at Nossaman and co-chair of our employment practice group. I'm honored to be joined this morning by my colleagues Pavneet, Julia, and Varan, who are also employment attorneys at our firm. Each of us provides advice and counsel to management on a broad array of employment-related issues, in addition to conducting workplace investigations and trainings and defending employers in administrative proceedings and civil litigation, including single plaintiff and representative and class actions. We've seen it all, so if you ever have an employment-related issue that you need assistance with, please reach out. We're happy to assist in any way we can. Before we begin, I'd like to cover some housekeeping items. Following today's webinar, you will receive an email with links to download the slide deck and to access a recording of the webinar. If you have any questions during the course of today's webinar, we invite you to send them to us by clicking on the Q&A icon at the bottom of your Zoom window. We will address any questions we receive at the conclusion of today's presentation, assuming we have adequate time to do so. If we run out of time and we're not able to get to all questions, we will reach out to you individually by email following today's program. After the webinar concludes, you will see a prompt to fill out an evaluation survey. If you have a few minutes, we would greatly appreciate your feedback on today's program. Finally, this program has been approved for 1 hour of general California, Texas, and Washington State CLE credit. If you requested such credit during registration, we will send you a completion certificate after we verify our attendance records. Our presentation today is broken into 2 major sections. First, we'll spend the majority of our time covering changes at the legislative and regulatory level. And then we will jump into, in the second portion of today's presentation, some significant case law developments that employers should be aware of in California. Throughout today's presentation, in addition to explaining how these new laws and case developments may apply to your operations and workforce, we will provide practical solutions and best practices for employers to stay compliant in 2025. So I'm going to kick it off by talking about the minimum wage increase. Well, Proposition 32, which would have raised the state minimum wage to $18 an hour for larger employers, narrowly failed at the ballot box last month. The minimum wage in California is still increasing by 50 cents to $16.50 an hour for all employers, regardless of size. I will note that there are higher minimum wages for certain fast food, restaurant, and healthcare workers, so employers in those industries should make sure that they are compensating employees at the applicable minimum wage rate that applies. Additionally, employers should determine if there are any living wage ordinances which may set higher minimum wage rates in the cities and counties in which they have employees working, and be mindful to ensure that you are complying with those higher minimum wage rates under the living wage ordinances to the extent that they apply. Finally, employers should make sure that all exempt employees are earning the minimum salary of at least $68,640 a year, starting on January 1st of 2025.
All right, let's talk about Senate Bill 1100, which is California's new law about driver's licenses in job postings. This includes advertisements, job applications, so your employment applications, and similar employment documents. Simply put, you can no longer throw must have a driver's license into every job posting or employment application unless you really need somebody behind the wheel. Why? Because not every job requires someone to channel their inner Uber driver. Unless the role involves actual driving, employers need to stop treating a license as some sort of golden ticket. The reason for this is to address discrimination that we have seen an uptick of in the workplace against individuals without driver's licenses. So this law is meant to eliminate this requirement as a condition of employment unless certain requirements are met. So what does this mean for you? How does the law work? You cannot include a statement that a job applicant must have a driver's license unless the following two conditions are satisfied in this slide. Number one, you as the employer reasonably expect driving to be one of the job functions of the position, and you reasonably believe that using an alternative form of transportation would not be comparable in travel time or cost to you. Now, what other alternative forms of transportation should you consider? The list includes, but is not limited to, Uber, Lyft, other ride-hailing services, taxis, carpooling, bicycling, and even walking. So for instance, if you're hiring somebody to deliver pizzas or drive the company van, yes, a driver's license is fair game. But if the job involves sitting at a desk or sending emails, asking for a license might land you in hot water. So what are the proactive relevant steps for you? Review your job applications, review your job postings or advertisements, and ensure that they comply with this new law. This law is set to take effect on January 1st, 2025. All right, so as many of you already know, California law prohibits almost all employers with 5 or more employees from inquiring into criminal history on job applications and during the interview process before a job offer is made. In certain localities, however, employers have additional criminal history restrictions and obligations, the most recent of which are in LA County and in San Diego County. This type of law is also known as ban the box law. You might know it under that name. The law's aim is to reduce undue barriers to employment for individuals with criminal histories. The bigger one of the two is LA County's Fair Chance Ordinance, which went into effect on September 3rd, 2024. If you have 5 or more employees in unincorporated areas of LA County, you have some additional homework beyond California's Fair Chance Act. What is that? Number one is your job postings. Now, all of your job postings, including your job application, must have a required sentence which says qualified applicants with arrest or conviction records will be considered in accordance with the ordinance and state law. If you have phrases in your job applications or job postings that say no felons need to apply, no convictions, such language is now prohibited. So you not only need to remove such language, you also need to have a qualifying statement in there which says that you're going to be considering them qualified applicants, of course, in accordance with the ordinance and state law. Also, you already know that you cannot ask about criminal history before a conditional offer, that's the state law, but under the ordinance, even after extending a conditional job offer, you cannot ask candidates directly about their criminal history. You may do so only until you receive back their criminal background check. The sequencing is very critical, so it's important you follow it to the T or else you might get in hot water. Next, as you know, if there's something in the criminal history that you don't like and you think it's relevant to the job and you do not want to hire the candidate anymore, you have to participate in an individualized assessment. Now, the LA ordinance has some further restrictions beyond the California law. Under the LA ordinance, the look back period now is only 7 years. Under California law, and typically you generally look back 10 years, right? So under the LA ordinance, the look back period is only 7 years. And also, if you're going to have questions about non-criminal infractions, they're also going to be prohibited, except for driving related infractions for jobs that require some sort of driving for work, like a truck driver. These limitations certainly exceed the restrictions you have in state law. And last but not least, unlike the state law under the LA County's ordinance, you need to hang the required notice of the ordinance somewhere visible in your workplace. Think lunchroom, break room, or wherever employees stare at walls, I guess, would be where you would need to put the LA County ordinance up. In addition to this, we have the San Diego Ban the Box update as well. The good news with the San Diego County's Fair Chance Ordinance is that it largely mirrors the California state law, but there are some key differences. Most significantly, if you intend to take adverse action against an applicant for, their employment or transfer or promotion based on their criminal history, you must conduct a written individualized assessment to determine whether the individual's criminal history has a direct or adverse relationship with the specific duties of the job that justifies the adverse action. As a practical matter, we always advise our clients anyways to conduct this individualized assessment in writing, but the California version of the law doesn't have this requirement where you must conduct this assessment in writing, but the San Diego County's ordinance does. Another deviation from the California's Fair Chance Act is, in addition to the individualized written assessment, the San Diego ordinance also calls for unique pre-adverse action letters. Now, some of you might be familiar if you have businesses in San Diego, but San Diego does have an Office of Labor Standards and Enforcement, OLSE, which mirrors what the DLSE does at the state level. So now, if you're in San Diego County, you have to also prepare unique pre-adverse action letters, which states that the employee or applicant has a right to file a complaint with the County of San Diego's OLSE for violations of the ordinance. And lastly, if you're really familiar with the state law, you will know that there are certain exemptions for employers from conducting this individualized assessment requirement, but that's not the case with the county's ordinance.
Okay, moving on to SB 553. So back in September of 2023, Governor Newsom signed Senate Bill 553 into law. Now, since July 1, 2024, this new law has required nearly all California employers to implement a workplace violence prevention plan, which must include components like employee training, incident reporting procedures, and hazard assessment. Essentially, this new law requires almost all California businesses to have a structured program to prevent workplace violence. There are some narrow exceptions to this requirement. These exceptions include places of employment where there are less than 10 employees working at a given time and the work site is not open to the public. There is also an exception for employees teleworking from a location of the employee's choice, which is not controlled by the employer. Healthcare facilities, law enforcement facilities, and facilities operated by the California Department of Corrections are also excluded from this requirement. Other than that, this new law does not have an implementation grace period and is already in effect. Covered employees were required to have their workplace violence prevention plans in place by July 1, 2024. And for many employers, this new requirement may have slipped under the radar. And there are many employers who may not have timely complied with this deadline. If any of our listeners are one of them, they should reach out to us so we can advise on the best way to ensure compliance moving forward and either address any delay-related issues. Once the plan is in place, there are various ongoing requirements for employers under SB 553. This include reviewing and updating the plan, soliciting feedback, providing training to employees, including on an annual basis, and also when there are updates to the plan or new hazards are identified. Employers are also required to maintain various records of workplace violence incidents and make certain records available to Cal OSHA employees and their representatives. Okay, moving on to another new legislation. Employers in outdoor settings have been required to follow heat illness prevention rules for some time now. But in light of this new law, California employers must also comply with indoor heat regulations. These apply to all indoor workplaces where the temperature reaches or exceeds 82 degrees while employees are present. There are even more strict requirements for indoor workplaces where the temperature is 87 degrees or higher. This new rule became effective on July 23, 2024, and is already in place. Getting more specific, for indoor workplaces where the temperature is 82 degrees or higher, employers are required to maintain a written heat illness prevention plan, which must include procedures for providing access to water and cool down areas, acclimatization procedures, and emergency response measures. I do want to note that these plans must be available at the work site and accessible to employees, as well as to Cal OSHA upon their request. And And to ensure that the procedures of the plan are actually followed, employers are also required to provide training to employees and their supervisors who may be exposed to heat illness risks. And as I mentioned, there are additional requirements when the temperature goes higher, 87 degrees or higher, or even in cases where it might actually be 82 degrees, but it feels hotter due to certain conditions. Specifically, these additional requirements can be triggered when employees are wearing clothing that restricts heat removal, or employees are working in high radiant heat areas. In these circumstances, employers must follow these additional requirements, which include measuring and recording the temperature and heat index regularly and implementing control measures to protect employees from heat-related risks. Okay, another new legislation update, AB 2975. With an increase in incidents of workplace violence in healthcare facilities, this new legislation now requires that hospitals use weapons detection systems at key entrances. These entrances must also be supervised by trained personnel who are not involved in patient care. If you're on in the healthcare industry, you might already know that many hospitals already have some sort of weapon detection protocols. This legislation, however, now requires that Cal/OSHA Standards Board amend its standards by March 1 of 2027 to officially incorporate this weapons screening requirement. This means that some discretion on the implementation of a weapons detection systems is going to be taken away from hospitals, and instead, hospitals will need to follow the standards set in place by the Cal/OSHA Standards Board. There also might be some additional costs associated with this because, as I mentioned, these entrances have to now be supervised by trained personnel who are not involved in patient care. So this will be some new employees that will likely have to be hired. The policy includes several key requirements. One, the weapon detection systems must be used at specific entrances to automatically screen individuals. Hospitals are also required to assign appropriate personnel who meet specified training standards to manage the screening. So like I mentioned, there will be some additional costs associated with implementing these new standards that will be set by Cal/OSHA. There must be additional requirements. There must be protocols in place for handling situations where patients, family members, or visitors refuse to go through the weapons detection screening. Also, hospitals need to have clear protocols for how they'll respond if a dangerous weapon is detected. One last note, the standards set in place will also include a requirement that hospitals post notices to the public, notifying to the public that hospitals conduct screenings for weapon entry, but that no person will be refused medical care on that end.
So moving on, we have Assembly Bill 2123, which pertains to the state-run paid family leave program. As many of you are aware, that program provides up to 8 weeks of benefits to employees who need to take time off work for certain specified reasons, including to take care of an ill family member or to bond with a new child. Previously, it was the case that employers could require their employees to use up to 2 weeks of paid accrued vacation that they had before accessing paid family leave benefits. Beginning in January, employers will no longer be permitted to require that of their employees. That is to say that employees will be able to access the 8 weeks of paid family leave without having it impact their vacation benefits. So to the extent that it's been an organization's practice to require their employees to take accrued vacation leave before accessing paid family leave, that practice should be discontinued. And then, of course, with that, to the extent that an organization has it in their employee handbook or other standalone policy addressing the paid family leave program, if that requirement has been set forth in writing, it should be eliminated. Next, we have Assembly Bill 2499, which resituates or repositions and expands certain existing rights and also creates some new rights for employees to take time off work to obtain relief in connection with qualifying acts of violence, which is a new term that's defined in the legislation, which we'll go over. As far as the existing rights, California law has already for some time provided protections to employees from against discrimination and retaliation for taking time off for jury duty or to make certain court appearances, as well as to obtain various forms of relief where the employee is a victim of crime or abuse. So up until now, those protections have been captured under the California Labor Code. Moving forward, as a result of this legislation, those protections will be captured under California's Fair Employment and Housing Act, which means that the California Civil Rights Department will have enforcement authority. The legislation also expands the protections afforded to victims, as well as changes or expands which employees will qualify as a victim in the first instance. So the legislation broadly defines victim to mean an individual against whom a qualifying act of violence is committed. So what is a qualifying act of violence? It means an incident of domestic violence, sexual assault, or stalking, which those were already captured under the previous or under current legislation. Moving forward, a qualifying act of violence is also going to include an act, conduct, or pattern of conduct in which an individual causes bodily injury or death to another, in which an individual exhibits, draws, brandishes, or uses a firearm or other dangerous weapon with respect to another, or in which an individual uses or makes a reasonably perceived or actual threat to use force against another to cause physical injury or death. So one of the important things to note here is that an employee can qualify as a victim of a qualifying act of violence, regardless of whether anybody has been arrested for, prosecuted for, or convicted of committing a qualifying act of violence against the employee. The law also extends leave protections to employees whose family members are victims. This is one of the really critical changes to the law. Previously, employees typically could only take leave if they were themselves the victims of a crime. Moving forward, family members, employees who have family members who are victims of a qualifying act of violence will also be eligible to take leave. As I mentioned earlier, the protections are now contained within the Fair Employment and Housing Act, which means the FEHA's definition of family members will apply. And that definition includes children, parents, grandchildren, siblings, spouses, domestic partners, or a designated person. Many of you will recognize that term as well as the definition from the expansions to the California Family Rights Act from a couple of years ago. So just as a reminder, a designated person is any individual related by blood or whose association with the employee is the equivalent of a family relationship. It is somebody that the employee can identify at the time that they request to take leave. And then again, as is the case under CFRA, an employer can limit an employee to one designated person per 12-month period. The legislation also expands the reasons for which an employee may take time off, including those that are captured on this slide. So to provide care for a family member who's recovering from injuries caused by a qualifying act of violence, to obtain or help a family member obtain certain relief, for example, a temporary restraining order. I won't run through the rest of these, but you can see them on your slide. And I will note that the legislation captures additional reasons. So there's a list of 10 reasons or 10 categories of reasons for which employees can take leave. So employers will just want to familiarize themselves with those reasons. Additionally, the law does specify that employees are entitled to use vacation, paid sick leave, or other paid time off they have available to them for the purposes of taking leave under this law. So the legislation also expands eligibility for reasonable accommodation. It's always been the case, right? Many of you are aware that the employer has been required to provide reasonable accommodation to employees who are victims of crime. However, given now that the definition of who qualifies as a victim has expanded, as well as given the extension of rights to employees who have family members who are victims, it just may be that moving forward, there will be more employees who will qualify or who will be able to request and receive reasonable accommodations where they may not have been covered previously. And the law does specify certain examples of what may constitute a reasonable accommodation. There are certain leave limitations, specifically if the employee that is requesting leave is themselves the victim of a qualifying act of violence. The employer can limit their total leave allotment to 12 weeks. If the employee that's requesting leave has a family member who is the victim of a qualifying act of violence, the employer can limit their leave time to 10 days or just 5 days if the leave is taken in order to assist a family member with relocating. Additionally, leave taken by an employee will run concurrently with leave taken pursuant to the FMLA and CFRA. And then employers, and again, this was true previously, and it remains true that employers can require employees to provide certification before they take leave under this law. So essentially to provide proof that they are in fact a victim as defined by law, or they in fact have a family member who's a victim of a qualifying act of violence. So that certification can take the form of something more formal, if you will, like a police report or a court order. But the law is also clear that that certification can just be in the form of a written statement signed by the employee, essentially certifying that they're taking the leave or requesting the accommodation for a authorized purpose. And then finally, there are some notice requirements accompanying this legislation. So employers are required to provide written notice of the rights established by the law to all new hires, to all employees annually, and to any employee who requests it, as well as anytime the employer becomes aware that an employee or an employee's family member is a victim. The California Civil Rights Division is expected to publish a form notice by July of next year. Once that notice is published, employers can use that for the notice requirement. In addition to the notice requirements, employers should, of course, update the leave sections of their employee handbooks or, again, any other applicable standalone policies to make sure that all of these expanded and new requirements are captured, as well as updating the employer's paid sick leave policy to reflect the additional reasons for which employees can take leave. So moving on now to some new regulations from the Equal Employment Opportunity Commission relating to the Pregnant Workers Fairness Act. Moving forward, I will just refer to that as the Act. So as many of you are aware, the Act went into effect last year, and it requires covered employers, that includes both public and private employers with at least 15 employees, to provide reasonable accommodations to qualified employees or applicants who have known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless that accommodation would cause the employer an undue hardship. Next slide, please.
Sorry, it's not advancing.
So I can just move, or I'll just wait to see, maybe it's just blocked. But as we'll go on to discuss, when this act went into effect, Congress directed the EEOC to essentially put together regulations implementing the law. So earlier this year, the EEOC published those regulations and they took effect in June of this year. They are very, very expansive. It's a very lengthy document that contains a whole host of information pertaining to what employers should do and need to do to comply with the act. It defines various terms, provides examples. So hopefully if we can get the slides to start working, I will run through just a couple of key highlights from the regulations, but I will note that that would require a webinar in and of itself to run through everything that's included. So we can only just provide a couple of key highlights. And it looks like we do have our slides back up.
Just a moment, I'm trying to go back. Just a moment.
Okay, excellent. So as I said, we'll just provide a couple of key highlights from the regulations. One is the regulations do provide a non-exhaustive list of the conditions that may fall under pregnancy, childbirth, or related medical conditions, including what I have on the slide here. So pregnancy, past pregnancy, potential pregnancy, lactation, infertility. I won't read through everything, and I'll note that the regulations do identify additional conditions that may qualify as a related medical condition. As you can see, even just from the truncated list that's provided here, it is a very broad range of conditions and might include conditions that you wouldn't have otherwise expected that don't just relate to a current pregnancy or childbirth, but that can relate to conditions that exist before pregnancy, such as infertility or fertility treatments, as well as conditions that would exist after pregnancy, like postpartum depression. Another highlight is that the regulations reflect that the definition of limitation will be construed broadly to include even, quote, modest, minor, and or episodic impediments or problems, including things like fatigue or back pain due to pregnancy, pain while standing, even just seeking to limit exposure to certain hazards like secondhand smoke. So it's very clear from the regulations that limitations for the purposes of the act is going to be construed much more broadly than a disability for the purposes of the ADA or California's Fair Employment and Housing Act. And then one final highlight, the regulations do identify a number of accommodations that are deemed to be reasonable in most circumstances, including those identified on this slide. So as I mentioned earlier, the undue hardship analysis does come into play, meaning that an employer could still potentially deny an accommodation that's listed in the regulations on the grounds that it would create an undue hardship on the employer's business. However, that being said, because there are certain accommodations that are expressly identified in the regulation, it will be likely difficult to make the argument that it creates an undue hardship. So to the extent that an employer does make that determination that they're not able to provide an accommodations that is expressly identified, they'll just want to make sure that they have a very well-documented rationale for why that accommodation could not be provided. Yeah, that's it. For the other thing, I just again want to stress that was a very, very small fraction of what is included in the regulations. So I think probably the bigger takeaway here is just to be aware that these regulations exist, and as issues come up that may implicate the act, to know that you will need to consult the regulations and likely consult with counsel as well. And then we have a couple of workplace posting and notice requirements. So this first one is Assembly Bill 2299, which required the Labor Commissioner's Office to develop a model list of employee rights under California's whistleblower laws. So the Labor Commissioner's Office has now posted that model notice. It is available on their website. It's essentially just a one-page notice. In fact, I think the little image on the slide here is the notice. So you'll just want to make sure that you obtain a copy of it and post it as specified. And then we also have Assembly Bill 1870, which expands an existing notice requirement. So employers that are subject to workers' compensation system, which is most employers in California, have already been required to post a notice providing information relating to their current workers' compensation insurance carrier, who employees need to contact if they've been injured, what kind of injuries and illnesses qualify under workers' compensation law. So that's already been the requirement, and this legislation expands that and specifically provides that the notice must now also include that injured employees may consult a licensed attorney to advise them of their rights under workers' compensation laws. So again, you'll just want to be sure that you have an updated workers' comp notice that provides the required information.
Okay, turning now to the Freelance Worker Protection Act. This act creates new requirements for contracts between hiring parties and freelance workers that are entered into or renewed on or after January 1st of 2025. The term freelance worker has a very specific definition that you'll want to take note of. It is defined as a person or organization composed of no more than one person. That's a significant limitation. Whether or not that organization is incorporated or employing a trade name, that is hired as a bona fide independent contractor by a hiring party to provide professional services for $250 or more. And the $250 is either by itself in one contract or when aggregated with all contracts for services between the same hiring party and the contractor during the immediately preceding 120 days. Professional services in this act is defined with the same meaning as provided under AB 5, which is California's independent contractor law, and includes services such as marketing, human resources, graphic design, fine artistry, photography, editing, and others. I will note that this law does not apply to the U.S. government, the state of California, or any subdivision thereof, foreign governments, and individuals providing services to themselves, their family, or their homestead. This act, to the extent that it applies, requires the contract between the hiring party and the freelance worker to be in writing, and then there must be very specific information included in that written contract. Those pieces of information are the name and address of each party, an itemized list of all services to be provided, the value of the services, and the rate and method of compensation, the date for payment or a mechanism for determining that date, the date by which the worker must report services completed for timely payment. Additionally, the hiring party must be provided with a copy of the the hiring party must provide the freelance worker with a signed copy of the contract, and the hiring party needs to retain that contract for at least 4 years. In addition, there are some payment timing requirements in the act. So under the act, the hiring party must pay the freelance worker on or before the date that compensation is due as specified in the contract itself, or if the contract doesn't specify a date, no later than 30 days after completion of the services. And additionally, once the freelance worker has started performing services under the contract, the hiring party may not require that freelance worker to accept less compensation than originally specified in the contract as a condition of timely payment. In addition, there are some anti-discrimination and anti-retaliation provisions in this act that employers should be aware of. So moving forward, private employers should identify any contractors with whom they work that may meet the definition of a freelance worker under this act. And to the extent that your business is renewing a contract with a freelance worker as defined by the act, or entering into a new contract after January 1st, then you want to make sure that you have a written contract in place, that written contract satisfies the requirements of the act, and that you timely pay workers in accordance with either the contract or within 30 days of the worker completing services. Turning now to some amendments under the Crown Act. For some context, in 2019, California enacted the Creating a Respectful and Open Workplace for Natural Hair Act, also known as the Crown Act, which made California the first to ban discrimination based on traits historically associated with race, including but not limited to hair texture and protective hairstyles. Protective hairstyles are defined under the act to include such hairstyles such as braids, locks, and twists. This year, amendments to the Crown Act were signed into law. The first set of those amendments extends the Crown Act to the Unruh Civil Rights Act. The Unruh Act prohibits discrimination by businesses, including in housing and public accommodations. In addition, the amendments modify the definition of race in the Fair Employment and Housing Act to eliminate the requirement that the trait be historically associated with race. And in the legislative history accompanying this bill, it's noted that determining whether a trait is historically as opposed to culturally associated with race is necessarily ambiguous and besides the point, so long as the trait is closely enough associated with race to serve as a proxy for racial discrimination. I will note that this bill applies retroactively because the legislature stated that it was a declaration of existing law. So employers will want to make sure that they review any written policies that reference historical traits associated with race and modify those policies appropriately to comply with the Crown Act amendments. Additionally, we have a further extension of the Unruh Civil Rights Act and the Fair Employment and Housing Act with this new piece of legislation, SB 1137. With this legislation, California became the first state to explicitly protect against what's called intersectional discrimination. This bill amends the Unruh Act and the FEHA to prohibit discrimination on the basis of not just one protected trait, but also on the basis of the combination of two or more protected characteristics. Here, the concept of intersectionality acknowledges that there are different forms of inequity and inequality that may operate together and exacerbate one another and can result in amplified forms of bias or prejudice or discrimination. So employers should review their written policies here again to make sure that they're compliant with this amendment. Turning now to restraining orders. So existing law authorizes an employer to seek a temporary restraining order on behalf of an employee who has suffered unlawful violence or a credible threat of violence from any individual, where that violence or threat can reasonably be construed to be carried out or to have been carried out in the workplace. However, absent unlawful violence or a credible threat of violence, the sort of harassment that might be legally sufficient for an employee to seek a restraining order on his or her own behalf has not been legally sufficient to support a request by an employer on the employee's behalf. However, with the enactment of SB 428, that's changing. So effective January 1st, under this new law, an employer whose employee has suffered harassment may seek a temporary restraining order on behalf of the employee or others. For purposes of this new law, harassment is defined as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person and that serves no legitimate purpose, which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress. There is a high bar to receiving a temporary restraining order under this act. So it would require the employer to show by clear and convincing evidence that the employee has suffered harassment, that great or irreparable harm would result to the employee, that the course of conduct at issue served no legitimate purpose, and that issuance of the order would not prohibit speech or other activities, whether protected by the National Labor Relations Act or any other law. Now turning to the new California Worker Freedom from Employer Intimidation Act. This new law, which will take effect on January 1st, prohibits both private and public employers in California from holding so-called captive audience meetings. Those are employer-sponsored meetings where the employer communicates its views about religious or political matters, including unionization. I will note that there are exceptions for certain religious, political, and educational institutions. So this law prohibits an employer from subjecting or threatening to subject an employee to discharge, discrimination, retaliation, or any other adverse action because the employee either declines to attend an employer-sponsored meeting, a captive audience meeting, or the employee declines to participate in, receive, or listen to any communications with the employer or its agents where the purpose of that communication is for the employer to express its opinion about religious or political matters. This act may be enforced by a private civil action or by the labor commissioner, and provides for damages, civil penalties, punitive damages, and injunctive relief. I will note that this law in all likelihood will be challenged on federal preemption grounds and or constitutionality grounds. However, if you are an employer that does not intend to challenge the law, you should make sure that any meeting that is held where either political or religious content is going to be discussed, that meeting is attended by employees on a purely volitional basis, and that the voluntary nature of the meeting is clearly articulated, ideally in writing, to employees in advance of the meeting. Additionally, employers should review and update any policies they might have that are currently in effect relating to captive audience meetings.
All right. With that said, let's talk about Senate Bill 1340. Your local agencies are now joining the fight against discrimination. The new law expands the enforcement of discrimination violations by requiring California's Civil Rights Department, which was formerly DFEH, as you know, to collaborate with local agencies. What does this mean? Local agencies now have a seat at the table, and they can help investigate and enforce discrimination complaints. What do you need to do as the employer now? First, keep in mind that there's more eyes on you, more oversight, and yet another reason to tighten up your practices. The steps we provided here are somewhat comedic, but they are truer than ever. Number one, stay vigilant, but don't become paranoid. You don't need to wear a trench coat and spy on your employees, but being proactive about discrimination complaints, even statements made in passing that can remotely be construed as complaints, will save you headaches later. Also, document like it's a scrapbook. If it's not written down, it didn't happen. I'm sure you will hear us say that a lot throughout this presentation, and if you're our clients, you've heard us say that as well. Number three, train your teams, your managers, your HR personnel, and your employees, and also build an HR fortress. And what I mean by that is equip your HR team with policies, procedures, and lots of caffeine. Complaints don't clock out at 5 p.m. and timely responding to complaints is critical to show the employer's good faith due diligence in investigating complaints. The overall takeaway from this is with local agencies now getting involved, you can't afford to let anything slip through the cracks. You have more reasons now to be more vigilant than ever before. All right, so a lot of you on here, I've seen the list of attendees. You've probably heard about the new PAGA amendments from me or from the team here. We're going to spend a brief amount of time talking about the PAGA overhaul that happened because of Senate Bills 92 and Assembly Bill 2288. These are this is a landmark law that totally changes the landscape of the Private Attorneys General Act. It is a much anticipated reform for California employers. Some of the changes are good, some of them not so much. I've highlighted some of the key changes to PAGA. The first is that the plaintiff must have personally suffered each of the violations alleged. This is kind of a game changer. You would think, of course, you need to personally suffer the violation before you can file a lawsuit against your employer. Not so under PAGA. Previously, you could have filed a claim for just one violation that you suffered and alleged 10 more violations along with it, and you could still bring those 10 additional claims on behalf of other employees at the company. The next one is the 1-year statute of limitations. Again, this shouldn't be groundbreaking, but it somewhat is. There's a 1-year look-back period for PAGA claims, but not only must plaintiff now have personally suffered the violation, they must have suffered it within that 1 year of bringing their PAGA claim. This clarification was in direct response to a controversial holding by a California Court of Appeal. The next is no weekly civil penalty. So for those employers that issue weekly pay stubs to employees, rejoice. No more weekly penalties for continuing violations. You know, if you've been hit with PAGA lawsuits before, that because you have weekly pay stubs that you issue to employees, your penalties are technically doubled under PAGA because you issued double the amount of wait statements. So this clarifies that there's no weekly civil penalty. It's going to be the same as those employers that issue pay stubs every 2 weeks or twice a month. The last is manageability, which is more so for your attorneys instead of you, but just know that your attorneys now have an additional tool to fight PAGA claims in court. Oftentimes we have employers that have a wide range of non-exempt employees who work very different types of positions and are subjected to different rules. So manageability could be a defense that your attorney should keep in mind. All right, here are some additional changes to PAGA. I'm going to move through these quickly just because we're short on time. We have 9 minutes left. There's prohibition on derivative penalties now. So basically, penalties can no longer stack like pancakes. If a single violation snowballs into other issues, you won't face other penalties for those derivative violations. This is specific to the untimely payment of wages and wage statement violation claims. You're also able to cure more violations. So now you can cure meal and rest break violations, minimum wage, overtime, business expense reimbursements, and wage statement claims. But yeah, proceed with caution with this one. This is one of the changes to PAGA that I don't love, because in order to cure violations, you first have to admit that there were violations in the first place. And if you're admitting that there was a violation that you're going to cure, sure, you might limit your exposure under PAGA, but now you're exposing yourself to additional claims on a class-wide basis for those same labor code violations. It's like the last time I fixed a leaky faucet, the basement flooded, right? You don't want to result in additional, you don't want to have additional exposure just by admitting you did something wrong. So it's important that you consult with your legal counsel and carefully consider whether it's worth even going the cure routes. Also, for employers that have fewer than 100 employees, there's an early resolution and neutral evaluation process. It's a fast-track way to settle claims without a courtroom showdown. The LWDA, the Labor and Workforce Development Agency, will help set up a settlement conference, and you'll get a chance to resolve the claim like grown-ups. For small employers, it's a lifeline, but for large employers, unfortunately, you're out of luck. And last but not least, there's newly available relief for aggrieved employees. Now they basically get a bigger slice of the penalty pie. So it's a slight win for employees from that perspective, lesser money in their attorneys' pockets. We can move on to the next slide. All right, so now this is a big one. Under the PAGA reforms, penalties can be capped if you take reasonable steps to comply with the law. What are those reasonable steps? I'm going to first go through them one by one, and then we'll discuss what the caps look like. So reasonable steps aren't automatic. You actually have to do the work. What does it look like? The first reasonable step under the law is conducting periodic payroll audits. So treat your payroll records like a car. Regular maintenance, helps prevent breakdowns. Audits help spot errors early so you can fix them before they turn into costly violations. And having that paper audit trail allows you to cap the penalties. Number 2, disseminate lawful written policies, hand out clear, compliant policies. Whether the employees read them, that's on them, and that's something to discuss later. Number 3, train your supervisors. Supervisors, as you know, are your boots on the ground. If they're not trained to enforce your policies, everything else falls apart. And number 4, take prompt corrective action. When issues arise, don't wait, fix them quickly. A swift response is your best defense and will help avoid escalating minor hiccups into full-blown legal battles. So you have now shown that you took these reasonable steps. What do the penalty caps look like? PAGA penalties are capped at 15% for employers who demonstrate that before they receive the PAGA notice or request for employment records from a PAGA plaintiff, that they took some of these reasonable steps or all reasonable steps to comply with the labor code provisions. And the cap goes up to 30% if they demonstrate that within 60 days of receiving a PAGA notice, they took all reasonable steps to comply with the labor code provisions. Again, though, to emphasize, in order to cure violations, you first have to admit that there were violations in the first place, and that could expose you to class action liability for the same underlying claims. So it's important that you discuss the strategy with your legal counsel to see if these cure provisions are even worth your time. Now, I also list this additional step for employers. It doesn't take time to update your employee handbook annually. I urge you all to do it if you aren't already doing it. As you know, California compliance laws, they change more often than your Netflix recommendations. A yearly update really helps ensure that your policies don't become relics. Next, and finally, if you are particularly my clients and attending, and I see several of you here, you will smile when I talk about arbitration agreements, because well-drafted arbitration agreements are a critical defense measure for your organization. They can help streamline dispute resolution and limit exposure, but you need to make sure that your arbitration agreements are enforceable. With that said, I'm going to hand it over to Varun, who's going to discuss some important case law updates related to arbitration.
Okay, shifting gears and looking at some recent case law updates with some important updates for employers to be aware of. I'm going to run through these pretty quickly. The first case on this list is Cook versus University of Southern California. This is a recent case dealing with the enforceability of arbitration agreements. In this case, the arbitration agreement was held to be unconscionable because it applied claims unrelated. It applied to claims unrelated to the employee's job and lasted indefinitely. It also lacked mutuality. It required the employee to arbitrate her claims against USC and all of USC's related entities, but it did not require USC's related entities to arbitrate their claims against the employee. Basically, the agreement provided a significant benefit to USC without the same benefit being provided to the employee. Next case on the list are Ramirez versus Charter Communications. Again, a significant ruling from the California Supreme Court on arbitration agreement. Another arbitration agreement that was held to be unconscionable by in court because it included things like it made the person resisting the arbitration pay the other party's attorney's fees. It required arbitration for claims that employees typically bring, but not for those employers bring. Again, a lack of mutuality in that sense. And it had components like shortening the statute of limitations for claims in a way that was unreasonable. Also, the court in this case clarified that courts need to take a qualitative approach when looking at unconscionability, looking at totality of circumstances. Another case, next slide, please, Garcia versus Stonehenge Furniture. In this case, the arbitration motion to compel arbitration was denied based on the finding that the employer had failed to prove the authenticity of the plaintiff's signature. because the evidence that just was provided was just declaration that summarily concluded that the plaintiff had signed the agreement. So while these rulings are not, can I get the next slide, please? These rulings are not very employer friendly, but they do provide some valuable insight on measures employers can take to ensure that their arbitration agreements are enforceable. These include things like reviewing the duration of it, the scope, ensuring mutuality, accessing third-party provisions. Again, these are good guidelines and to be aware of in reviewing arbitration agreements to ensure they're enforceable. In terms of ensuring the validity of electronic signatures, there are also steps that employers can take. Sending a link to the employer's personal email, sending a confirmation of emails, or any of these listed recommendations. Basically, the goal here is for a court to be able to make the finding that only the employee and only the employee was the person that could have signed this arbitration agreement.
So moving on to another case update, I do want to note really quickly, I realize that we will be running over. If you're able to stay with us, that would be great. To the extent that you do have something else to get to, we understand, and thank you for your attendance. And I will just note that the webinar is being recorded, so you will have access to it and you can finish viewing this at a later time when it's convenient for you. So I will move on now to another another notable decision from earlier this year, Muldrow versus City of St. Louis. In this decision, the U.S. Supreme Court lowered the standard for the degree of harm that an employee alleging a discriminatory job transfer must experience in order to establish a viable claim under Title VII of the Civil Rights Act. So I will just provide a little bit of factual context for you. The plaintiff in this case was a female who was employed as a police sergeant. She alleged that she was forced to transfer jobs because her supervisor wanted to place a male officer in her position instead, because he felt that the male officer was better suited for the dangerous role. Notwithstanding that she was transferred to a different position, she did maintain the same rank and the same salary and much of the same benefits. However, her employment did change in some respects. She had a different schedule. She lost some of the perks associated with her prior position. For example, the department-issued vehicle, and some of her duties also changed. So she essentially argued that she was moved into a less prestigious and more administrative type role and sued under Title VII for sex discrimination. Before I get to the court's ruling, just as a little bit of legal background, the court had previously interpreted Title VII to require a plaintiff to demonstrate some disadvantageous change in the employment terms and conditions in order to establish discrimination, along with, of course, establishing a discriminatory motive for the change. So the lower courts in this case concluded that in order for the employee to prove that a job transfer was quote unquote disadvantageous, she needed to prove that the job transfer caused a materially significant disadvantage, and that the plaintiff in this case had failed to do that because, again, like I said, she did maintain her ranking, she maintained her salary, and the courts determined, to the extent that there were changes, they were more minor changes. The United States Supreme Court rejected that approach and that reasoning and concluded that the plaintiff only needed to show some injury. She didn't need to meet any sort of heightened standard to prove that the job transfer was disadvantageous. And also the court clarified that the some harm that the plaintiff experienced did not need to be limited to economic or tangible changes in the terms and conditions of employment. The meaning of some harm was left rather ambiguous. The court essentially just said that she needed to establish that she was somehow worse off than she had been before the transfer. But as far as additional guidance, we expect that future rulings will flesh out further and provide some more insight into what exactly a plaintiff needs to establish to show some harm. It's also unclear from the decision if it is limited only to job transfers, which was the issue being decided here, or if it will extend to other employment actions. We expect, of course, that employees bringing suit under Title VII and their attorneys will seek to apply the lower standard in the context of other employment actions, not just job transfers. And based on this decision, they'll likely have a strong argument to do so. So moving forward, this is for employers just to keep in mind as they make decisions about job transfers, but also other employment decisions, that, again, the employment decision does not have to result in a really significant change. It doesn't need to result in a change in salary or rank. It can, even a more minor change might support an action for discrimination under Title VII. And then we have a more positive development on the wage and hours side that came from the California Supreme Court's decision in Naranjo versus Spectrum Security Services. In this case, the Supreme Court unanimously held that an employer is not subject to statutory penalties for providing incomplete or inaccurate wage statements if the employer reasonably and in good faith believed that the wage statements were accurate. So this case affirms that employers can raise a viable defense against claims for penalties for wage statement noncompliance. Again, assuming that the employer can show that it reasonably and in good faith believe that the wage statements were compliant with the law. So we expect that California courts will be they're not just going to take the employer's word for it, right? They are going to scrutinize this defense. So the key here really is being able to show good faith, and that gets back to a lot of what Pavneet was discussing earlier, just with respect to conducting periodic audits of payroll, reviewing policies, ensuring everything is up to date and compliant.
And now turning to our last substantive slide of today's presentation. Thank you for sticking with us. And this is another decision from the California Supreme Court in Stone versus Alameda Health System. This is another rare piece of good news for public agency employers from the California Supreme Court. For some context, there was case law in California prior to this decision that stood for the proposition that the provisions of the California Labor Code only apply to employees in the private sector unless they are made specifically applicable to public employees in the statute. And in this case, the California Supreme Court affirmed that public agencies are not employers within the meaning of the meal and rest break provisions of the Labor Code and the applicable wage order. Of course, many of us believed that to be true, but the court here brought finality to that particular issue. In addition, the court held that penalties under the Private Attorney General's Act of 2004 do not apply to public agencies. So here the court highlighted the limited reach of state wage and hour provisions as to public employers, and brought some clarity and finality to these particular issues, at least for public agencies.
Thank you all for taking the time to join us today for the webinar. We hope you found the information insightful and valuable as you prepare for these upcoming changes. Please be sure to fill out the survey that'll pop up as you exit the webinar. Your feedback is invaluable to us as we continue to improve and tailor our sessions to your needs. Unfortunately, we're out of time to address any questions live. However, for those of you who did submit questions, rest assured our team will follow up with you directly via email to provide the responses you need. On behalf of the entire team, I'd like to wish you a joyful holiday season and a wonderful close to 2024. Thank you again for joining us today, and we look forward to connecting with you in the future.